Welcome and thank you for joining us this afternoon. This webinar is hosted by the Faculty of Law at the University of Toronto, a vibrant intellectual community that is home to a diverse range of ideas and approaches. We wish to acknowledge the land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently the Mississaugas of the Credit River. Today, this meeting place is still the home of many Indigenous people from across Turtle Island, and we're grateful to have the opportunity to work on this land. The Faculty of Law's stature as one of the very best law schools in the world rests on the excellence and diversity of our faculty, robust clinics and centers, and the caliber of our students. And it is my pleasure to introduce you to our speaker today. Professor Kent Roach is the Prichard Wilson Chair of Law and Public Policy. He has been editor-in-chief of the Criminal Law Quarterly since 1998. He's the author of 14 books, including most recently Canadian Justice, Indigenous Injustice, the Gerald Stanley Colton Boshi case. In addition to many publication awards, Kent is a fellow of the Royal Society of Canada, a member of the Order of Canada, and has received the Molson Prize and was named in 2016 by Canadian Lawyer magazine as one of the top 25 influential lawyers in Canada, Changemaker category. He has been a member of the Canadian Council of Academies expert panels on policing and subsequently on Indigenous policing, as well as having worked on the Hyperwash, Arar, and Air India inquiries, all of which involved policing. Joining Kent today is Ian Scott, who has spent most of his career as either Crown Counsel or Defense Counsel. He has both prosecuted and represented police officers involved in the on-duty lethal use of force. From 2008 to 2013, he was the director of the province's Special Investigations Unit and currently acts as investigative counsel for the Ontario Civilian Police Commission, the Ontario Judicial Council, and the Justices of the Peace River Council. Ian has taught courses in criminal law, criminal procedure, and police accountability at Western Law School. Ian is currently under contract with Thomson Reuters to write Community Safety and Policing Act and Special Investigations Unit Act, an annotated guide. Before I turn the floor to our speaker, let me just say a few words about the logistics. At the end of his presentation, Kent and Ian will answer as many questions as possible in the time remaining. Please type your question into the Q&A feature at the bottom of your screen. This webinar is being recorded and a link of the recording will be emailed to all the registered. Once again, welcome and thank you for joining us today. Kent, the floor is all yours.
Thank you very much, Mariana, for that generous introduction, and thank you all for attending this talk. I recognize that we are in a difficult and sensitive time. I also recognize that as a person who is neither a police officer or an Indigenous or other racialized person, that I must tread carefully and with empathy for all. But I do think that now is the time to have a serious discussion about policing. I'm worried that Canadians in general tend to be both complacent about race relations and trusting of police, and that this is not a good combination. I think this may explain some of the muted responses to the recent police killings of 3 racialized persons in the Toronto area, DeAndre Campbell, Regis Korchinski-Paquette, and most recently, Ajas Chowdhury. It also may explain the muted responses to the police killings of Chantel Moore and Rodney Levy and to a lesser extent, the violent arrest of Chief Alan Adam and the Mona Wang incident. So I think it's, although there's a question mark on the lecture, I think that we are at a crisis state. The only thing that makes me hesitate is when I started teaching criminal law in the late 1980s and early 1990s. Of course, we were looking at things like the Lester Donaldson killing in Toronto and the J.J. Harper killing in Winnipeg. So it is something that we need to look at now. There's going to be three main parts to my talk. The first is going to be looking at the issue of over and under policing through the lens of systemic discrimination. Although the question of whether there is systemic discrimination has offered some challenge for RCMP leaders, both the commissioner and the leader in Alberta, it should not be a hard question for anyone who has been paying attention to answer. 30% of our prison population is Indigenous. We don't have as good figures for the Black population, but 7 to 9% at least are prisoners are Black. These are both young and growing populations. As late as 2006, the RCMP were commissioning academic studies that put things like racial profiling into scare quotes and suggested that it was more about perceptions than reality. Over-policing is what occurs when there are disproportionate investigative stops, traffic stops, arrests for street drugs, and arrests for public intoxication. Under-policing occurs when there is disproportionate crime victimization. In the 2014 victimization study, 28% of all Indigenous people reported that they had been victimized by crime in the last year, compared to 18% for the non-Indigenous population. It's also represented in things like the missing and murdered Indigenous women and girls reality. But there's a common thread to both over and under policing, and that is a bad history between the police and Indigenous and Black groups. It's a bad history that extends from residential schools to pipelines, from slavery to segregation, to a long list of police shootings and deaths. We know from Robert Peel that the police should be the public, and the public is the police. The RCMP, who I'm going to focus on for this talk, has done some employment equity work. The most recent statistics suggest that almost 22% of RCMP officers are female, 11.5 are visible minorities, and 7.5 are Indigenous people. In fact, the last is the only category where there is proportional representation, and in fact, even a bit more over representation. But of course, this raises a question. Employment equity may be necessary, but it may not be sufficient, especially confronted with the reality of police culture and the difficulties that many racialized groups within the police force, certainly not all, but many, report. So what should we do about over-policing? Well, here I'm going to be a little bit of a heretic for someone who is a criminal law professor. And here I'm actually borrowing from some of the ideas that my colleague Marty Friedland has long articulated. But it seems to me that one of the issues in over-policing is that we are increasingly relying upon ex post adjudication in criminal and civil courts, often under the Charter. I'm not opposed to charter litigation, but I'm very concerned that the same problems of over-policing, investigative stops, searches that shouldn't happen, Mr. Big, strip searches, seem to occur over and over again, even when the courts do recognize and respond with remedies. And so one of the things that I'll be proposing at the end is that we need to either have the criminal code take a more proactive approach and have policies and directives, perhaps more like the English PACE Acts, or alternatively, with respect to the RCMP, that the Minister of Public Safety, which is in charge of the RCMP, the Commissioner is under the direction of the Minister of Public Safety. I see no reason why the Minister of Public Safety could not issue directives and regulations that were publicly available, and indeed, I will suggest later, publicly debated. One of the things that Justice O'Connor recommended in the Arar Commission was an increased use of ministerial directives. And this provides a way of making clear to everyone what policies are governing the police. Now, the under-policing problem, I think, is a more difficult problem. Here, I will move to the second part of my talk, which is really about the funding of the police, or perhaps provocatively called defunding and refunding. I understand that defunding is for some a controversial and off-putting term, but the reality is that in 2018, Canadians spent $15 billion on policing. In 1987 and 1988, as I was starting off my journey in criminal law, we spent about $150 per person in this country on a per capita basis on policing. Today, in constant dollars, we spend $318 per person on policing. Now, of course, most of that money goes to salaries, and most police officers earn $100,000. So even before the COVID-19 pandemic and the calls that we see to defund the police, there were concerns that the funding levels of the police were simply not sustainable. And so I'd like to suggest to you is whether or not you think it's a good idea that we spend less on the police. I happen to think it probably is. There will be defunding of the police as we try to recover from this pandemic and the effect that it will have on government revenues. The Canadian police were relatively sheltered from the effects of the 2008 recession. More sheltered, my research suggests, than police in the United States and the United Kingdom were. I don't think that is going to work this time. The RCMP, again, commissioned work, academic work, that tried to justify the cost of policing by comparing it to the cost of crime. In my view, given the lack of accurate and sustained research that suggests the police actually affect the level of crime, I don't think that strategy will work or should work this time around. But to say that defunding or reducing funding of the police is not a panacea. In fact, there is one area of policing that has already suffered from declining policing. And perhaps it's the area that should have been the least subject to police cuts. And with this, I talk about the policing of Indigenous communities. And we will be making available to you after this lecture the free books that the Canadian Council of Academy did, both on policing and separately on the policing of Indigenous persons. The Canadian Council of Academies is a body that is designed to give the government the best knowledge that is available on pressing policy issues. But to go back to Indigenous policing, since 1992, the number of self-administered Indigenous police forces has declined from 58 to 36. So many of you probably on the news last night saw Chief Alan Adam say that within 5 or 10 years he wants the RCMP off of all reserves. That's a lot of work, because now the number of self-administered police forces is actually decreasing, and most Indigenous people in Canada are policed by the RCMP, the OPP, the Sûreté, and municipal. Even more shocking, in 1996, of those communities that were covered by the federal Indigenous policing, about 90% of the people doing the policing were Indigenous people. By 2014, the number was 26.7. And 1/3 of eligible First Nations and Inuit communities have not entered into the federal program, either in terms of the self-administered separate police forces or through community tripartite agreements between the community, the police force, and the federal government, that attempt to give communities somewhat more control over policing. From 2007 to 2018, the funds were frozen for Indigenous policing. That explains why many people left, why the salaries received by those policing Indigenous communities were significantly less than those policing non-Indigenous communities, and why Indigenous communities and police forces often had poor equipment and facilities. So that's one area where we're probably going to have to spend more money. In 2018, the federal government committed $291 million spread over 5 years, but there are still some real concerns about that program and whether it is sufficient to overcome the bad history between police and Indigenous people. And if you're interested in that, the Canadian Council report contains more information. Now, the RCMP, which is my focus, is going to face some real challenges in the years ahead. The most recent budget suggests that it spends $3.2 billion on contract policing, almost 18,000 people. But the future of contract policing in the RCMP is far from clear. The town of Surrey in British Columbia has indicated that it is going to move away from contract policing and create its own police force. And Alberta has also indicated some interest in developing its own provincial police force. So I think that in some ways, to borrow the phrase of Joseph Schumpeter, we're going to get into an area where there may be some creative destruction when it comes to the RCMP. I think the RCMP is always going to be a national police force, but they only spend, or only, 830 million on kind of the core national functions related to national security, organized crime, financial crime, and they only have about 5,000 FTE devoted to that. In Alberta alone, there's over 4,000 RCMP officers and 113 detachments. So if Alberta develops a provincial police force, that's going to be a huge hit for the RCMP. Now, I agree with Commissioner Lucky when she said yesterday that we have to fund, or I would say refund, social and mental health services. I don't know, and I'll talk a little bit about this, about whether the concern that the police always have to be there in dealing people with mental distress. This has recurred. We've heard this from the police many times. It is a legitimate concern. People do try to commit suicide by cop. That is a real thing, and Ian Scott can talk about that with greater knowledge than I can. But I think that one of the things we need to do is build up not only de-escalation, but also retreat and waiting as police strategies, or at least we need to have a democratic debate about that. I also note that the Black Parliamentary Caucus, if you read what they've said about policing, they also talk about investing in Black business. And again, I mean, the economics of this is something we cannot ignore. So we know that both Black and Indigenous males have much higher unemployment rates and are probably going to suffer more through COVID. And this is something that we really do have to grapple with. So in conclusion, I think with respect to funding, I really do think that the police are going to have to deal with less in the upcoming years. I also think that one way that they can deal with that is by putting more civilians and also considering disarming some police officers. Again, I've recently spent some time teaching in England, and perhaps that has influenced my approach. But I'm also influenced by the fact that when the Harper government in 2006 decided to arm the Canadian Border Service agency, they committed $1 billion over 10 years to that project. So, one of the cost-cutting measures might be to have civilians play a greater role in policing, and unarmed civilians, or even some unarmed officers. Now moving to the third and last kind of major topic before I throw out some reform ideas. I'm going to get into the issue of accountability and governance. And here I am going to allow Ian Scott in because although we wrote our op-ed together and we're good friends, we don't always agree completely on this topic. So one of the things that we've seen is the development of SIU, independent investigators for police-involved deaths and serious injury. These are available in most provinces. They're not available in New Brunswick. So this is one of the reasons why the Quebec Bureau d'Enquête has been called in to investigate the two recent deaths in New Brunswick. Now, I just want to make clear, because I don't want Ian to get too mad at me, I believe SIUs are bedrock rule of law institutions. And I think that as Canadians, we should be proud that they exist. Having said that, as a criminal lawyer, and as someone who's looked at SIUs from afar for a number of years, they are bogged down in problems of police cooperation. a lot of struggles with the police, sometimes with the police associations. They have issues of public confidence and transparency. And some of this is built in through the process of criminal investigations, which are typically not done in a completely open and transparent way. They've achieved very few successful prosecutions, and in some cases, acquittals of police have been interpreted by the wider community as the idea that the conduct is okay. As a criminal lawyer, I worry, right? Because the police, like everyone else, should have the benefits of the presumption of innocence, proof beyond a reasonable doubt, and so on. But I worry that although we carefully investigate, and sometimes prosecute police, we see the same patterns happening over and over again. And one pattern that I think we're all familiar with is the mentally distressed person who has a knife and who ends up being killed by the police. And so whether it's SIU or police complaints, I think what we need is more integration of these necessary accountability mechanisms with police policymaking. And I'm going to suggest that that is a much tougher nut to crack. Now, before I move on to governance, I just want to say a little bit, and we mentioned this a little bit in our op-ed, about the Civilian Review and Complaints Commission for the RCMP, because I think that Canadians don't know enough about this, and this is an institution that is in dire, dire need of reform. It's got a budget, depending on real allocated or expense, of between $9 to $11 million. And this is to oversee and review complaints of the RCMP with almost 30,000 people that operates from coast to coast to coast. So to put that in perspective, that's a much smaller budget than, say, the Faculty of Law at the University of Toronto has. The Toronto Star has recently reported that there are 181 reports done by this commission. And of course, they don't do reports in most cases. They're just there if a person is not satisfied with how the RCMP has resolved their case. The Toronto Star has recently reported that there's 181 reports that are not being released because they're sitting on a desk somewhere in RCMP headquarters. And 67 of those have lasted more than 2 years. Now, to its credit, the commission is doing some important systemic work. It has ongoing investigations, systemic investigations on strip searches, investigative stops, and the Colton Bushy case. These are all extremely important, but they're not either completed or having been released. And so I think that, one of the things that I will be proposing is a kind of complete revamping of the RCMP Act, including the complaints process. Now, having said what I've said about accountability, how does accountability flow into governance and policy making? Because I'm increasingly, and I'm doing some work now on remedies, where accountability is backward looking, what happened. But increasingly, I think we have to pay attention to how to prevent repetitive harms and reoccurrence of harms. And for that to work, it has to be fed in to a police policy making process. And here, when we come to the RCMP is the least democratically governed of all of our police forces. There is no real police board as there is for municipalities. There is an interim advisory board that was created largely because of the sexual harassment problems and is tasked with dealing with corporate risk. But we need to have better governance of the RCMP. Even locally, Justice Morden's report on the G20 revealed some real problems with the capacity of police boards in Ontario. Some work has been done to address that. And then we also have the reality is that politicians and police board members who take a strong stand with respect to policing tend to become unpopular very quickly. So, you think in Toronto, Gordon Chong, Susan Ng, John Sewell, all of these people have at various times disagreed with aspects of policing, but I think it's fair to say have paid a price for that. So what's one of the problems here? Well, I've done a lot of work for commissions, including the Ipperwash Commission over the years, on issues of police independence. What should be the relationship between civilian governance and the police? Now, I'm not a total skeptic of police independence. I accept that if the board or any board member or the Minister of Public Safety, in the case of the RCMP, could say to the police, well, you better investigate that Roach character and don't investigate that Scott character, that would be improper. We would live in a police state. Whether the United States has reached that is another question for another day. But one of the problems, and Justice Linden in his Ipperwash report documented this, is what happens when it comes to the policy of operations. So what happens if the democratically accounted governors of the police want to proclaim policies with respect to public order policing, with respect to use of force, that the police and police associations may not particularly like. And it seems to me that that's a difficult debate. That's a difficult public policy debate. There are some examples in the United States arising out of consent decrees that suggest that sometimes it's best to get the union on board, better in the tent than outside the tent. But one thing I think that should be clear is that these policy debates, and that's what they are, policy debates, should not be affected by claims of police independence. They should not be affected by the idea that it's totally up to the police to decide how they will use force, how they will police protests. I think in a democracy, we have to accept that that's something that is open for democratic debate. So I think it is very important that we legislate, both with the RCMP and provincial acts, a definition of police safety, police independence, and that it be limited to individual law enforcement decisions whether to arrest, have search warrants, and so on, but that it should not extend as far as police operations. I believe that that's consistent with the little bit that the Supreme Court of Canada has said about this issue in Campbell and Sherrose. So the last thing that I'll say about accountability and governance is the RCMP will soon be unionizing. And again, that's another challenge that the RCMP will be facing. And I accept that there's a lot of job dissatisfaction, a lot of distress, frankly, among police officers. I think that will be reflected, has already been reflected in the overwhelming support for unionization. But I think, the federal government really has to think about how that is going to complicate the story of reforming and changing the RCMP. And I don't have any ready answers for that, but I know that that's going to be an issue. So in conclusion, and I want to leave lots of time for your questions and for Ian to chime in. In conclusion, I'm going to suggest 3 paths forward that really kind of summarize what I am have talked about. The first, with respect to over and under policing, is I think we need more ex-ante regulation of police conduct through the criminal code and through ministerial directives. I think that this can benefit the public, and I also think it can benefit the police. It's hard enough for me as a law professor to stand, to keep up on all the zigs and zags of the Supreme Court's jurisprudence on this question. And I think that we need some rule making. With respect to the funding of the police, I think we really have to seriously consider a moratorium on more sworn officers. A lot of police are of retirement age. And in fact, I would not be surprised, given recent controversies, if I was a police officer and I could retire, I probably would retire right now. I think we need to consider a moratorium, but taking any money that is saved or available and putting that into general community safety and wellness funds, and to encourage the police, if they want to have access to those funds, to partner, to use a hub-like model, to partner with health and community groups and others, and to think of ways to use civilians better in policing. I think Canada lags behind, say, the United Kingdom with respect to that. I'm also not sure that we need a fully armed and trained police officer to respond to traffic accidents, to do wellness checks. And I think that we really need to think about a fairly radical restructuring of policing in the future. And finally, with respect to governance and accountability, I think we need to completely rewrite the RCMP Act. I think we need to go back to basics. I think the RCMP Act needs to have operative principles, as is the case in many other countries. I think it needs to have things like provincial, territorial, and local community and detachment boards of governance. Ian and I talk a little bit in our op-ed about the Yukon Police Council. 3 people appointed by Yukon, 3 people appointed by First Nations. I think that's the sort of thing we need to do. I think it's in the RCMP's interest, if they are going to retain contract policing, that they be more responsive to local communities. Just recently, a Saskatchewan law has been passed that the RCMP is so far not cooperating with. We need a definition of police independence in the RCMP. That's a narrow definition. We need a mandatory list of police policies or ministerial directives or police policies in the RCMP that should be subject to public notice and comment. And this can include things like the use of chokeholds, dealing with people with mental distress, de-escalation, and so on. We need separate legislation for an independent inspectorate for the RCMP that will review both conduct for propriety and efficacy. So we need to really move far beyond the RCMP commission. And then we also have to figure out the role that the Mounties New Union will play in all of it. So those are my thoughts. I'm sure that there are lots who disagree, and I look very forward to your questions, and we'll let Ian now handle the questions. Thank you.
Thanks, Kent. We do have a few questions, some which are duplicates, and some, frankly, you answered during the course of your talk. But just a couple of points. Going back to the RCMP for a moment, isn't there even perhaps a more basic question of the RCMP? Do we really need or want a national policing service such that with a mandate or remit that goes from anything from patrolling in northern Alberta to very sophisticated counterterrorism, surveillance and protection of international persons that you mentioned as a relatively small part of what the RCMP does? Might it be that the baggage of the RCMP is such that we're not going to be able to escape it until we move the wine into new bottles, perhaps? To some degree, you indicated that's already starting to happen. In Surrey, for example, they've left contracting police with the RCMP. And you mentioned Alberta toying with it, although I think last I looked at that issue, they're locked into a contract policing agreement until 2032. And I think, there's a very strong reason why, other than Ontario and Quebec, that many other provinces have entered into these contract agreements. From what I understand, there's a very significant subsidy given to the provinces through the deployment of these resources. But maybe their day is over. Maybe having an RCMP that's ultimately commanded from Ottawa, I appreciate there's a lot of delegation down to the deputy commissioners, is just too attenuated. And there's too much baggage, as you indicated, in the past, particularly with the Indigenous community. And it's time to look at a greater degree of specialization in this area. Any comments on that?
Yeah, no, I think that is definitely on the table. As I said, I think the RCMP will always have some role in kind of national policing, but that's the RCMP focus on national policing is going to be a much smaller entity, and in some ways that may make sense. I think to a certain extent there needs to be, dare I say, a little bit of market competition here, and not insisting that the people be tied in by long-term contracts with respect to contract policing. But at the same time, I would be a little bit worried if there was no federal role. And of course, the federal role can just be, and you indicated this through the subsidy issue, through the spending power. Right. So the federal role with respect to Indigenous policing is extremely important. It hasn't adequately been filled in the past, but I would, kind of hate to see there being no federal role, although it might be a much lighter footprint and one based on the spending power. And I think that one of the things the federal government needs to do is articulate a kind of vision about what they want to support if there is indeed policing innovation. Because, if the RCMP get out of contract policing, that's an earthquake in Canadian policing. But it's also a time for, very kind of, it is creative destruction, because every, municipality that wants to try it and every provincial force has to deal with these issues. And I think we need a federal role. I didn't say this in my main talk because it always sounds like special pleading coming from academics, but policing research in Canada compared to the United Kingdom and even the US is, pretty pitiful. And, one of the things that I think the federal government can do, and it hasn't really done so far, is to encourage experimentation, right? Maybe we can just have mental health nurses respond to the vast majority of calls, but with some kind of special beeper that if there's safety issues, they're the first priority. But frankly, we don't really know what works and what doesn't work. And, the American experience, is far from perfect, but after the Rodney King beatings and riots, the feds did, now of course not under Trump, but the feds in the United States did take an active interest in local policing, especially when it revealed patterns and practices of rights violations. So yes, I mean, you're right that in 20 years from now, I have no doubt the RCMP is going to look different. I think it should look smaller, but I'm also not sure that one size fits all. It may be that Alberta is ready to think about this. Saskatchewan and PI may not be. But we are coming into a creative area. And again, this is why I think, we need to have public debates about this. And, I say this with trepidation. I think we also need to include police unions, because whether we like it or not, they're a powerful force.
Okay, moving on to some of the comments you made about the SIU. If I being a good student here, I tried to take a couple of notes. You indicated it was bogged down, but with issues of police cooperation, issues with transparency, and very few successful prosecutions. I mean, I'm the first to agree that in a better world, you wouldn't need the SIU. You wouldn't need any ex post facto forms of accountability, either in a criminal context or in a public complaints non-criminal context. But the reality is, at least from my view, I would think, is that we do need these mechanisms to be effective in all our jurisdictions. Yes, indeed, I can tell you at a very real level, the problems that you can run into in terms of doing investigations of the police and serious injury, death, and allegations of sexual assault. However, notwithstanding all of the problems associated with it, I would be of the view that you still have to have that entity. The way to facilitate public confidence in it is to, and I appreciate you and I perhaps differ on issues of how much independence should be involved, but it has to be independent of the police, the police agencies. It has to be as transparent as possible and as thorough as possible. And there has to be a system of decision-making within it which is accountable, either through reports that are public or through the criminal justice system. Having said that, I appreciate that the number of charges are very low, but they probably should be. And to some degree, even though the charges are low and fed into the criminal justice system, the conviction rate should probably not be as high as the regular conviction rate, simply because of the unique status of police officers, the fact they should be of previously good character before they enter into policing, and some of the special defenses they have. So regrettably, in some ways, people always want the big bang of a big prosecution and conviction. That's not going to happen. But because it doesn't happen, I would suggest we ought not to throw the baby out with the bathwater. Any comments?
Yeah, no, I mean, I agree with that, but I also think part of the problem is where does the knowledge that is gained from SIU type investigations, how does this impact, and also coroner's inquest, how does this impact police policy making, right? So, I think about the issue of a knife and whether you fire shots into central mass, often killing a person. I don't know the answer to that. I don't have any kind of special expertise, but I worry about kind of the policy cycle. So, I mean, I agree with you that it's a bedrock rule of law institution, but I also think that we need to develop a kind of different debate, especially when, it's not an option, as apparently is in the United States, in most police forces, to fire people right away before they are prosecuted. Tomorrow we're going to have the verdict come down in the DeFonte Miller case. it'll be interesting to see what happens. So I mean, I would never abolish the SIU, but I would want it to feed into police policy and police training and research about the police in a more sort of effective way that indicates that the criminal law is the absolute minimum that we can expect from the police. It should never become a de facto maximum.
No, I totally agree with everything you said, and I was of the view when I was there. In fact, it's increased. I mean, the SIU has now been around for 30 years, approximately 300 odd occurrences or incidents per year. There's a massive repository of information in the SIU files, which many academics could, harvest, and some have. Scott Wortley, for example, at the University of Toronto Criminology Department has looked as a background paper in the Ipperwash matter on issues of disproportionate use of force against Indigenous and I believe other visible minorities.
Yes.
And indeed, there's a push, which I think has now happened, where there will be better stats kept on the incidents of the SIU so that information can be harvested. But I've often thought that, there ought to be more academics looking through the material. But I do see this as a very separate function than doing criminal investigations. Because as we know, if you're ever going to lay charges, and it is going to happen, the parameters of the investigation have to be pretty clear. They have to be there for criminal investigative purposes because there are unique powers that investigators have in those circumstances. And ultimately, all this is going to get fed into potentially a criminal justice system with a prosecution. And accordingly, we have to be quite careful on how we circumscribe what the SIU does on at least an operational basis.
Yeah.
So,
No, I mean, I agree, but I mean, I guess I would just add though that, I think this has an effect on police unions. I think that there's not enough research in Canada about police unions. When the Supreme Court struck down the RCMP's approach, they cited one academic article that had been written in 1980, which is really, quite pitiful. And I actually see one of the biggest effects of police unions are, paying for lawyers and lawyering up, which I agree with you is a right. If I'm being criminally investigated, I want a lawyer present, but I worry about an adversarial attitude then bleeding over into things like legitimate policy debates about use of force policies. And that's why I put the stress that I do on defining police independence in a limited way. I mean, that police independence, I think, is an esoteric subject. There's only a few of us in the world who seem to write about it, but I see it present in a lot of these debates that we have about policing. And so again, I think some legislative definition would help. Perhaps there's some questions from.
Well, indeed. In fact, your response feeds right into a question that was from one of our audience members, and I have attempted a bit to sort of consolidate the odd questions so that we don't cover a lot of ground twice. So here's the question: quote, do the associations or employment agreements protect the officers too much and act as a catalyst for bad behavior, including racist attitudes? Unquote.
Yeah, well, I mean, most collective agreements that I've looked at, and they're actually not as easy as they should be to find, to find, do have provisions both for lawyers and indemnity. So that I think is a real issue. And of course now the new bill that governs labor relations in the RCMP was cut back from, there was quite a few restrictions on what could be subject to collective bargaining. Almost all of those went when former police officers in the Senate and others objected to them. And of course, health and safety is a key kind of labor issue. So there's not some, easy issues here, but I think that we need to be more aware of police associations and what is in or not in the collective agreement.
Yeah, I mean, my personal view is some of this emphasis on the associations is a bit misplaced. I mean, unions do what unions do and lawyers do what lawyers do. Unions protect their members, and that indeed is their job. There's a bit of an issue with police associations. Sometimes people confuse them with police leadership, but really it should be police leadership that is indeed taking the lead and making sure that the associations are not really stepping out of school. But, you know, in my view, the associations absolutely have a role, not only health and safety issues, but they're dealing with management, just like frankly, any big organization. Yep. So I'm certainly not, sorry, go ahead.
No, I'm cognizant that we only have 5 minutes. So
sorry. Yeah, let me move ahead here.
Yeah, why don't you give me 2 or 3 questions and I'll answer the easiest one.
Okay, Professor Roach, you mentioned amending the criminal code as potential ex ante reform. Is the immunity for peace officers using force in Section 25 of the code something that should be either changed or reviewed?
Okay, next question.
Well, this may relate as well. Let me try this one because I'm trying to cluster them a little bit. You mentioned that changes to policies and directives in the criminal code and oversight of the Minister of Public Safety could mitigate the effects of over-policing. Which directives and policies do you believe to be worth implementing?
Okay. So yeah. So the last question, Mr. Big, why are we relying upon the Supreme Court to call the balls and strikes on Mr. Big when it can be done through a ministerial directive? I mean, certainly the case in Victoria that ended in stay of proceedings seemed to me like a pretty egregious misuse of millions of dollars. The charter, and abuse of process sets the minimum protection. It doesn't necessarily have to set the maximum. On Section 25, of course, we've already had some changes, some litigation way back in the 90s about the fleeing felon rule. As those of you who, the very few of you who may have looked at my book on the Gerald Stanley case know, I have some worries about the new self-defense provisions, which are in some respects arguably more permissive than Section 25. But certainly I think Section 25 and Section 34 of the Criminal Code are things that we should look on. Another example would be strip searches. The OIPRD has documented widespread non-compliance with the golden rule on strip searches. The majority of the court called for legislative regulation and it never came. So the only legislative regulation we have is, basically, the 50 different warrants we have, all in response to Supreme Court decisions. So again, I think there's a better way to do this.
And I think you mentioned earlier how they deal with this issue in England, which is the PACE Act. Is it not called police?
Yeah. So, I mean, one of the things that they do in Britain is that they have, guideline directives. So everything doesn't have to kind of be in the criminal code. It could almost be a kind of amendment. And one of the things is that the state of police research in Britain is much more advanced. So there is an idea that you can revise these directives so that there actually is a channel that we can change the directions to the police about what works and what doesn't work, and we can have a public debate about this. And again, obviously they would have to satisfy the minimum standards of the charter, but I think that going in this direction could actually make the life of police officers easier, but also prevent some policing tactics that we know are pretty high risk and that strain public confidence.
Okay, one final question. It has to be a relatively crisp answer. What do you think of body-worn cameras?
I'm not opposed, but they're not a panacea. And I think that, you know, with just the advent of all videotaping, we're going to deal with this issue more. We can no longer be, this issue is no longer in the shadows. It's permanently in the light, whether there's body cameras or not. But obviously body cameras are one source of increased transparency. So I would support that, but it's not a panacea.
Okay, very good. I apologize to many people that have sent questions in. We just haven't had an opportunity to get to them, but I note the time and I turn it over to our moderator, who I think is on the line.
Yes, hi, it's Raquel here from the Advancement Office. So I just wanted to thank you, Kent and Ian, so much for taking the time today to lead the webinar. And just thank you to all of the Faculty of Law's alumni, students, and friends that participated today. Note that I will be sending a follow-up email with the webinar recording and supporting documents that are recommended by both Kent and Ian. And I just want to thank everyone again and have a lovely rest of your day.
Thank you very much.
Thank you very much. Thank you for taking your time.
Thank you.